In the name of God, the compassionate, the merciful, welcome friends to the 52nd episode of Crime and Punishment. I want to reiterate, as I do every week, that this is a legal podcast, not a political podcast. We have absolutely no political opinions here at Crime and Punishment. This is 100% legal analysis of legal cases. We are absolutely not going to talk about liberals crying all over the country today. We are not going to have anything to say about their political opinions or how wrong they are. We are only going to discuss the legal matters in the Supreme Court overturning Roe v. Wade today. We are only going to discuss the Supreme Court's expansion of gun rights in yesterday's ruling. We are only going to discuss the legal ramifications of qualifying Miranda rights, as the Supreme Court also did yesterday. We are not talking about politics. Now, with that being said, let's check the audio. Sound is good, says Richard. All right. Radical. First news of the day is this. Apparently, somebody has discovered that I'm not actually dead. Somebody has discovered that I am not in prison. I don't know who that would be, but it was a good time off, I'll say. I do enjoy private life. Now, corporate America is responding to this. We have the Daily Beast. So let's read the Daily Beast first, because we just need to give them the press. Armed man allegedly said he wanted to, quote, give his life a purpose, end quote, by killing Kavanaugh. Nicholas John Roske was arrested, that's R-O-S-K-E, was arrested near Kavanaugh's home at 1:50 a.m. Wednesday, which was June 8th. With a gun, a knife, pepper spray, zip ties, a crowbar, and a hammer, prosecutors said. This is the Daily Beast admitting that. Incredible. They wrote a whole article on it. And yet, not a single picture of Nicholas John Roske on here. In fact, you could hunt down a picture of Nicholas John Roske, and it'd be tough for you to find. No media outlet doxed this guy, right? Where are the articles that tell you everything about where he went to elementary school, middle school, where he lives, what his job was? So I recall another Daily Beast article recently where they pointed out, well, this guy who hit an African-American teenager, well, he worked at McDonald's. Everything you could ever want to know about the guy. And yet, the man arrested outside of a Supreme Court justice's home, who traveled clear across the country to assassinate said justice, we don't know anything about him. They don't even post his picture. And yet, check out this article from Vice News. Everything we know about the 31 Patriot Front members arrested in a U-Haul. A lot of people have asked me to talk about this case. This article is from June 14th. If you don't know, there was this trans thing going on, pride event, they call it. Patriot Front, a far-right group, went out to protest the event. Somehow things went south. They were all arrested before doing their non-violent protest. And here's Vice News heroically telling us everything we know about the 31 Patriot Front members arrested in a U-Haul. I'm not going to talk about it because obviously the only purpose of these articles, the only purpose of this being in the news, is to destroy these people's lives. It's not about anything legal. It's not even about anything political anymore. It is pure vindictiveness. And yet, nothing on Nicholas John Roske, to my knowledge. everything we know about Nicholas John Roski, the guy who was going to kill Kavanaugh and who was arrested outside his home, right? Nothing like that, no comparable articles, but Patriot Front protesting kids at a pride parade, for the love of God. Now those guys, those are the real criminals. Like I said, we're not talking about anything political today. Only legal issues. Now, I'm going to post the link to the newsletter last week. If you were not signed up, please feel free to do that. And there it is in the comments. We've also got the viral style. And of course, I forgot to do this week. I even forgot to contact the person who was going to do this week. That's how much I don't think about selling things on the internet. But there we go. There's viral style. Now, without further ado, let's talk about the Supreme Court. Supreme Court, several weeks ago, I reckon. I forget what day, but we talked about it on this program. Someone at the Supreme Court, we still don't officially know who, leaked the draft opinion by the majority that was going to overturn Roe v. Wade. That is how someone like Nicholas John Roski would get it in his head that he needs to travel clear across the country to assassinate a Supreme Court justice, because it was released so that there would be a national furor by abortion activists to scare the Supreme Court into not issuing that opinion. Obviously, that's the only reason to release something like that. Unprecedented. No pun intended. Still don't know who that guy is, right? But we know everything there is to know about those 31 Patriot Front members who were arrested for a nonviolent demonstration. Supreme Court has not backed down, amazingly. They did publish the Dobbs v. Jackson Women's Health Organization opinion. That was today, this morning. Yesterday, they published two opinions, both of which are supremely unpopular by half the country. One is Vega v. Tekoh. And to be honest, I don't know much about that one, but I am mentioning it because it is all the rage right now. And not for a good reason, either. The other is New York State Rifle and Pistol Association, Inc. v. Bruin. That is the one allegedly expanding gun rights. So let's talk about the easiest one first. And that's Vega v. Tekoh. And I'm going to go straight to the source of hysteria, Slate.com, which says the Supreme Court took the first steps toward overruling Miranda v. Arizona on Thursday, declaring that suspects have no constitutional right to receive the famed Miranda warnings when they're taken into custody. It's a 6-3 decision in Vega v. Tekoh. Its 6-3 decision in Vega v. Tekoh ensures that many suspects who are denied these warnings will have no legal recourse, even if they are wrongly convicted. Justice Sam Alito's opinion for the court lays the groundwork for a more direct assault on Miranda itself, barely concealing the conservative majority's contempt for the decision. A lot to unpack in that totally fair and neutral, unbiased paragraph. Let's start by talking about Miranda v. Arizona. You have seen it all over TV. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you, so on and so forth. These are called Miranda warnings. Because some time ago, some guy named Miranda filed pro se a certificate with the Supreme Court. Supreme Court said, you know what, you're right. If you're in custody, you should be advised of the fact that you don't have to talk, that you have the right to remain silent, because these police are out of control. These police are forcing confessions. We are getting numerous false confessions, people being convicted on the force of false confessions being brought into trial. So you're going to have to tell them now, when you have them in custody, hey, anything you say from this point forward, we're going to use it against you in court, or it can be used against you in court. But as I almost always tell people, it will be used against you in court. 99% positive on that. Slate is sounding the trumpet that the Supreme Court is about to overturn it, right? I don't know if that's entirely accurate. So let's go to the opinion itself and make some short work of this, because they're just sounding the alarm. It's a slippery slope, so on and so forth. Let's see. So it comes out of Los Angeles County Sheriff's Deputy Carlos Vega's case. Terrence Tekoh was the interrogated person. He was interrogated by Los Angeles County Sheriff's Deputy Carlos Vega, right? Now, Tekoh eventually provided a written statement apologizing for inappropriately touching the patient's something, right? This is a family-friendly program. We will try not to be too graphic, but he was prosecuted for this. His written statement was admitted against him in trial, obviously. After the jury returned a verdict of not guilty, Tekoh sued Vega under the 1983 claims thing, 42 U.S.C. 1983, seeking damages for alleged violations of his constitutional rights. The Ninth Circuit held that the use of an un-Mirandized statement against a defendant in a criminal proceeding violates the Fifth Amendment and may support a Section 1983 claim against the officer who obtained the statement. So Section 1983, that's when you're suing the cops, right? The cops did something wrong. I mean, it applies to a lot of other things, but when you're thinking of suing the cops, you're typically thinking about 1983 actions, right? Very difficult to do. It's a federal statute. Federal court is a different animal than your county or state court. It's just a different ball game, right? The Ninth Circuit is the appellate court. So this was in Los Angeles. So he must have filed in a federal court in Los Angeles. This was appealed at some point by somebody. Like I said, I'm not an expert on this. I didn't look at the whole history, but it must have been appealed by somebody to the Ninth District so that they could, as an appellate court, overturn it or uphold it. And the Ninth Circuit, they were the ones who held that it may support a 1983 claim against the officer. Well, now that it's going to the Supreme Court of the United States, the next highest court and the final, the ultimate court, is saying, no, it can't. Held. A violation of the Miranda rules does not provide a basis for a 1983 claim. That is the holding of the case. So the holding of the case is basically, what does this come down to? What is the court holding in this case? That's Law School 101. If you're going to describe this case in a nutshell, in one sentence, what is it? That sentence is, a violation of the Miranda rules does not provide a basis for a 1983 claim. So Slate is sounding the alarm that, oh my goodness, nobody's going to have any recourse whatsoever anymore. The world has gone mad. The Supreme Court's going to overturn Miranda. That's not necessarily true. I'm not thrilled about this opinion. Quite frankly, I think all cops who do things like this should be open to suit. I also think judges who knowingly make wrong decisions should be open to personal suit. I don't like this opinion. However, I don't see Slate's point that this is a slippery slope and all of a sudden we're going to have no rights in this country anymore because we can't sue cops personally because they did this, violated the Fifth Amendment because they didn't read you Miranda rights or whatever. I don't think it's gone that far. However, looking to the other decisions that have been published this week, you can see where they're coming from, because as soon as the court overturned Roe v. Wade, even when the draft was leaked, everybody was just apocalyptic about it. Well, if Roe v. Wade is overturned, you know that sodomy laws are next, and they're going to overturn gay rights and gay marriage and all the rest. And conservatives are saying, oh no, please God, no, anything but that. But of course, that's not what the Supreme Court's saying. However, we do see now Justice Thomas apparently wrote immediately after publication of Dobbs today that gay marriage might be next. Because if you're sending everything back to the states on abortion, saying we had no right to arrogate that authority here at the Supreme Court, this is a state's issue. This is not up to us to legislate for the entire country. We did this wrongly back in the 1970s. We're going to send it back to the states. If you're saying that about abortion, then why wouldn't the same thing be true of gay marriage, pride parades, sodomy laws, contraception laws? All of this came about at the same time, under the same court. So if you're sending that back because their legal reasoning was just absurd, which it was, then why wouldn't you send everything else back? So that alarm actually was sounded correctly by the left, I think, because now that this legal reasoning is on the record, it should apply to everything. And the question then becomes, and I don't see anybody sounding the alarm about this, but what about Brown v. Board of Education? What about segregation? I was listening last night at the gym to Patrick Buchanan's book on Nixon, which will get you super pumped up. That's why I listened to it at the gym. There was a part where he's talking, he talks all the time, Buchanan, about Nixon being totally against racism, totally against segregation. He was against the South on all of this. He had a Southern strategy in his presidential campaign, but personally he was absolutely dead set against racism, dead set against segregation. And Buchanan makes this point over and over, saying that Nixon has got a bad rap, and I don't disbelieve that at all. I don't even remember where I was going with that, but basically, if you're talking about Brown, that's where it was. He was talking about Brown v. Board of Education. So the Southerners at that time, while Nixon was campaigning, and at even earlier when the schools were being desegregated, they had this entire publication. All the congressmen who were in the South, and they pointed out Brown v. Board of Education is completely out of line. It is not based on any legal precedent whatsoever. This is clearly legislation by the Supreme Court. They are deliberately causing chaos and anarchy in the South, where this is going to affect most people, but also in the North. Busing and desegregation, it didn't just affect the South. It affected everybody in the country. That memorandum is gone, right? You don't learn about that in law school. You don't learn about Brown v. Board as being completely out of left field, right? You think of it as this landmark decision where its legal reasoning was absolutely sacrosanct. You cannot question this. Although, absolutely out of the blue, no legal reasoning whatsoever, if you were going to ask an honest lawyer about that. Same thing with Roe v. Wade, which is what the justices have pointed out in this opinion. It has no basis in American law. It is not founded in American history. This is an aberration that for 50 years we have put up with. It has caused nothing but chaos, and we need to send it back to the states where it belongs. Well, if that's the case, why not sodomy, gay marriage, desegregation? So now you have people like Keith Olbermann saying that the United States Supreme Court must be abolished. You have AOC and Maxine Waters in the streets saying that everyone needs to take to the streets right now. We're going to defy the Supreme Court, which is amazing. From the very people saying that Trump should be prosecuted for inciting an insurrection, they have declared the Supreme Court illegitimate. And they have told people to take action against it. What does that mean exactly? Clear disrespect for the separation of powers, which is why we're talking about it on this program. We are absolutely not discussing anything political. This is all a legal program, legal analysis, and you have congresswomen out there in the streets saying that this branch of the government, this checks and balance system that we have, it's illegitimate because they said our quote-unquote checks and balances back then, that was actually an arrogation of authority. We didn't have that authority. We're sending that back to the states. That's illegitimate. You have to take up and riot. Mostly peaceful protest against that. So let's read that opinion, shall we? Let's see if it's changed at all. Let's check in here. I'm here. Inverted Pilgrimage is here. Trad Dad is here. What's offered at Viral Style? We got a hat, we got a shirt, we got a mug. And it's not like, the store of the century over there. Ulfric. Late to the party here, Augustus, but happy to see you. What a lovely day it's been for states' rights. Hallelujah. Coach Alpha Elite says he's late. What's up, man? It is a day today. It is a week this week, and it's amazing that all these Catholic Supreme Court justices released this opinion overturning Roe v. Wade on the feast day of the Sacred Heart of Jesus. It had to be planned, right? There's no possible way that was just pure coincidence. Good afternoon, Brian from the East. Let's see, I've got this around here somewhere. Oh, we're already talking about Dobbs. Let's just talk about Dobbs. I was going to talk about New York State Rifle and Pistol Association, but let's just keep talking about this. Dobbs, State Health Officer of the Mississippi Department of Health et al. V. Jackson Women's Health Organization et al. That means et alia and others, by the way. Held. The Constitution does not confer a right to abortion. Wow. What a holding. The Constitution does not confer a right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elective representatives. Holy cow. Who ever thought we would see something like that in our lifetime? Just incredible. No ambiguity whatsoever to that holding. Roe v. Wade is overturned. Casey is overruled. The authority to regulate abortion is returned to the people and their elected representatives. You might recall Tucker Carlson, his analysis of this, where he was pointing out how insane it is for these people who are critical of the opinion to say, well, this is all about democracy, when the opinion explicitly says they are returning this authority to the people because the arrogation of that authority by the Supreme Court back in 1973 was illegal. It was anti-democratic. So let's continue with this holding. This is a rather long holding. It has subsections in here. Subsection A, the critical question is whether the Constitution, properly understood, confers a right to obtain an abortion. Casey's controlling opinion skipped over that question and reaffirmed Roe solely on the basis of stare decisis. A proper application of stare decisis, however, requires an assessment of the strength of the grounds on which Roe was based. The court therefore turns to the question that the Casey plurality did not consider. Subsection 1. So this is A1. First, the court reviews the standard that the court's cases have used to determine whether the 14th Amendment's reference to liberty protects a particular right. Before we go on to that, though, let's talk about stare decisis, because that's a term of art here. It basically means the decision stands. Look, the Supreme Court already ruled on this. We're not going to overturn it unless, there's obviously grounds for it, or that was obviously an illegal decision. We're not going to, have these cases where we just keep coming back to the court. Like, the decision's going to stand, right? And what they're pointing out is, however, that required an assessment of the strengths of the grounds on which that case was based. And so the Supreme Court in Casey, which affirmed Roe, it didn't actually consider that. So that's what we're going to do now. We're going to consider that. 1. First, the court reviews the standard that the court's cases have used to determine whether the 14th Amendment's reference to liberty protects a particular right. The Constitution makes no express reference to a right to obtain an abortion, but several constitutional provisions have been offered as potential homes for an implicit constitutional right. So you could liken that to saying, well, there's no right in the Constitution to privacy. People point that all the time. They're concerned about the tech state, the surveillance state, the technocracy, and people point out, well, there is no right to privacy in the Constitution, but constitutional scholars have argued, well, it might not say privacy in there, but we can infer, and we have these penumbras in the Constitution, and it's hidden in there somewhere. Like, you can infer, they meant there's a right to privacy, right? So people have said the same thing about abortion. Well, it doesn't say abortion in there, but right to privacy is in there, and women have a right to control their own bodies, and so on and so forth, and they do these mental gymnastics, and voila, now you have a right to an abortion, right? As many abortions as you want, on demand, no reason whatsoever. So that's what they're saying. Many constitutional provisions have been offered as potential homes for that right. Roe held that the abortion right is part of a right to privacy that springs from the First, Fourth, Fifth, Ninth, and 14th Amendments. The Casey Court grounded its decision solely on the theory that the right to obtain an abortion is part of the liberty, the quote-unquote liberty, it's in quotation marks, part of the quote-unquote liberty protected by the 14th Amendment's Due Process Clause. Others have suggested that support can be found in the 14th Amendment's Equal Protection Clause, but that theory is squarely foreclosed by the court's precedents, which establish that a state's regulation of abortion is not a sex-based classification, and is thus not subject to a heightened scrutiny that applies to such classifications. Legalese, basically, Equal Protection Clause, it doesn't count. 14th Amendment has the Due Process Clause, it has the Equal Protection Clause, and basically this means that there are certain phrases in that whole paragraph, and they take this phrase, and there's a whole, what we call jurisprudence based on that. A whole series of cases all across the country, just based on this one little phrase, the Equal Protection Clause. And then there's a whole nother set of legal cases all over the country for 50 years based on the Due Process Clause. And they're saying, well, one of these things, it just doesn't apply, and they said that a long time ago. Equal Protection Clause is not even at issue here. So that's some legalese, hopefully translated well enough for you. Rather, regulations and prohibitions of abortion are governed by the standard of review, the same standard of review as other health and safety measures. So that's number one, that the Casey Court did not consider. So these prohibitions on abortion are governed by the same standard of review as any other health and safety measures. There's no sacrosanctity to abortion above all other health and safety measures. That's number one. Number two, next, the court examines whether the right to obtain an abortion is rooted in the nation's history and tradition, and whether it is an essential component of, quote, ordered liberty, end quote. The court finds that the right to abortion is not deeply rooted in the nation's history and tradition. The underlying theory on which Casey rested, that the 14th Amendment's Due Process Clause provides substantive as well as procedural protection for quote-unquote liberty, has long been controversial. The court's decisions have held that the Due Process Clause protects two categories of substantive rights. Those rights guaranteed by the first 8 amendments to the Constitution, and those rights deemed fundamental that are not mentioned anywhere in the Constitution. In deciding whether a right falls into either of these categories, the question is whether the right is, quote, deeply rooted in our history and tradition, end quote, and whether it is essential to this nation's scheme of ordered liberty. The term liberty alone provides little guidance. Thus, historical inquiries are essential whenever the court is asked to recognize a new component of the liberty interest protected by the Due Process Clause. In interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about the liberty that Americans should enjoy. What a concept! You should consider what liberty actually means, what the nation's history of liberty actually means, and what you, Supreme Court Justice, believe liberty should mean for everybody, because that's what you personally believe. Far from being anti-democratic, this entire opinion is based on, it's not for us to decide what liberty is. That's for the American people to decide, so we should never have had that authority. The Supreme Court justices before us arrogated that authority wrongly, and we're going to give it back to the people. They can decide what liberty means. It's not up to us, is what they're saying. For this reason, the court has been reluctant to recognize rights that are not mentioned in the Constitution. Guided by the history and tradition that map the essential components of the nation's concept of ordered liberty, the court finds the 14th Amendment clearly does not protect the right to an abortion. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. No state constitutional provision had recognized such a right. Until a few years before Roe, no federal or state court had recognized such a right. Nor had any scholarly treatise. Amazing. Indeed, abortion had long been a crime in every single state. It's amazing to me, this is not the reading here. It's amazing that this even has to be spelled out for people. This country has gone so far insane that you actually have to point out that until Roe v. Wade, abortion was a crime, not a right. Killing a child in utero was a crime forever until 1973. And we have to point this out. That no state constitutional provision ever recognized such a right. That no support in American law was ever found for a constitutional right to obtain an abortion. That no scholarly treatise ever recognized such a right. That it was a crime in every single state until 1973. Roe v. Wade, this all-male court, decided, of course there's a right for women to kill their own children. Amazing that has to be pointed out. That people have gone so mad that they think this is about women's right to privacy. That this is somehow an attack on women's liberty by these male justices, not recognizing that, half the court now is female? At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have serious consequences at all stages. American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. Expanded criminal liability. By the time the 14th Amendment was adopted, 3/4 of the states had made abortion a crime at any stage of the pregnancy. That means there's no first trimester, second trimester, there's no, before the heartbeat, there's no up to the birth, there's none of that. There's no hemming and hawing, no hair splitting. It's any stage of the pregnancy, it is a crime to have an abortion. 3/4 of the states. This consensus endured until the day Roe was decided. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. Respondents' argument that this history does not matter flies in the face of the standard the court has applied in determining whether an asserted right that is nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment. Amazing how the mask comes off, isn't it? Well, look at the history here. Well, we have to do stare decisis, American history, this and that. And as soon as it's pointed out, actually, that was completely misstated. Well, what does it matter? Women obviously have a right to kill their own children. Amazing how that mask comes off as soon as it's pointed out that your entire argument was nonsense. Amazing how the mask comes off when this is coming up to bat and your argument at the Supreme Court in oral arguments is literally not that women have a right to privacy or women have a right to health care or anything of the sort, but women have a right to abortion. Period. Full stop. That was not how it was sold, was it? It was sold as, well, what about the case of rape and incest? What if some poor girl is raped and she's forced to have this child? When is that ever actually the case in these literally millions of abortions that we have had in this country over the past 50 years? Millions. Countless millions. How many of those were rape and incest? That was obviously never the point of Roe. That was never the point of legalizing abortion. And it's amazing, all these Twitter comments today, all of these Instagram posts today, social media is on fire with the Supreme Court is forcing us to have babies that we don't want. No one forced you to spread your legs. Not a single person. And in the case of rape, well, then you go back to that original argument. But that's obviously not what anyone was really arguing about, was it? The only thing people were arguing about was, I, as a woman, have the right to be sexually promiscuous without any consequence whatsoever. And to see women all over Twitter today, ladies in the audience, I know your exceptions. This does not apply to you. However, to see women all over Twitter, all over social media, all over the news today talking about, well, this is our right. We have to overturn this. We have to fund travel so that women can get abortions. It points out that the only reason for women to have the right to vote is so that they can vote to murder their own children. The overturning of the 19th Amendment cannot be far behind. This whole concept of voting might go right out of the window. So now that they've overturned Roe v. Wade, they may well overturn gay marriage, gay rights, the sanctity of sodomy. God forbid. But they could go back to Brown v. Board. Segregation is now legal again because it's sent back to the states. God forbid. Go all the way back to women voting. Go all the way back to voting at all. Go back to the founding of the country, which was founded on treason. Go back to the establishment of a republic as a treasonous act against the monarchy. Go all the way back, for all I care. Undo it all. The sad thing about modern America is that you can't say that, can you? Now again, this has nothing to do with politics. We are only talking about the law. I am an attorney. I'm talking about legal things. Voting is a government structure. It was brought about by legal means. The Constitution was shoved down everyone's throat. The common law is a discussion of law. Where did that come from? We adopted it from the English. The English got it from William of Normandy. William of Normandy, as we just learned a couple episodes ago, got it from Charlemagne. Thousands of years, right, of legal history are at stake here. Democracy is an aberration. Female suffrage, women voting to be able to murder their own children, is an aberration in human history. We've had 50 years of women murdering their children in this country, totally legal, without having to consult their husband or the father of the child. Totally legal, and now it is over. It is over, and now the left is calling for civil war. God forbid. I mean, that would be awful. But if it did happen, then let's throw out everything else too. going back to Charlemagne, for all I care. Where are we in this opinion? At common law, abortion was criminal in at least some stages of pregnancy. It was regarded as unlawful and could have very serious consequences. Endured until the day Roe was decided. Now, respondents' argument that this history does not matter flies in the face of the standard the court has applied in determining whether an asserted right that is nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment. In other words, they're saying, what does it matter if the Supreme Court misstated the history back in 1973? History doesn't matter. Women have this right. There's a right to an abortion. It's constitutionally protected. Even if it's nowhere in the Constitution, even if it's nowhere in American history, there's a right now. That's where we're at. So to continue, the Solicitor General repeats Roe's claim that it is doubtful abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. But the great common law authorities, Bracton, Koch, Hale, and Blackstone, all wrote that a post-quickening abortion was a crime. Moreover, many authorities asserted that even a pre-quickening abortion was unlawful, and that as a result, an abortionist was guilty of murder if the woman died from the attempt. Amazing. What women activists for abortion, any activists for abortion, men or women, what any of these people, they don't want you to point out either is that if you murder a woman who is pregnant, it's a double homicide. That's an inconvenient fact because that admits that the fetus is a person and you are committing homicide as long as you are not the mother. And that's what's amazing about this entire thing. Anyone else kills that fetus, it's obviously a murder. There's no question about it. But if the woman wants to murder her own child, 100% legal. That is insane. That is not legal. That is not a legal analysis. There is no way to say that with a straight face. It all comes down to this is a mask for something totally political and absolutely evil. And it's over now. It's over. You go out there walking around right now, you see people mad, people yelling, they are in a bad mood right now. You can point out, just like you could walk down the street and see a person in a mask, you know what side of the fence they're on. If you go out there in public today and you see mad people just in a grumpy mood, just snapping at people, looking at Facebook, you know what side they're on. Because anyone who is anti-abortion is having a great day today. It is impossible to get mad today. Who is Hold on a second. Just opening this. I haven't looked at the comments like the entire show. Probably got a lot of hate in here. Interesting time, says Padfa. Open carry and expletive deleted crushed. A match made in heaven, says no name. All right. Cosmos is pointing out something that actually was pointed out to me earlier today. I'm sure Cosmos knows that I know this, but the person who pointed it out earlier today acted like I had never considered this before. Oh, how could you not know this was going to happen, Augustus? Right? And that's this. Let's talk about the racial aspect of abortion. Again, absolutely a legal analysis. This has nothing to do with politics. I have no political opinions. But let's talk about race and abortion. Many white nationalists will point out the fact, correctly, I might add, that abortion disproportionately affects different races. That it is minorities who by and large get abortions, not white women. That's not entirely true. Obviously, white women get abortions. Obviously, this affects every female. Every female has a right to an abortion until today, thank God. But statistically speaking, yes. Black women have the most abortions. Minorities have more abortions than white people. And there is a certain section of white nationalists who believe that, well, we should keep Roe v. Wade. We should make abortion legal because otherwise we're going to be drowned out, right? Otherwise, the birth rate for non-whites is going to shoot through the roof. It's going to be astronomical. So we have to keep abortion, because otherwise, we're going to be flooded, 5 times as fast as we're already being flooded out right now. Be that as it may, that is not an argument to keep Roe v. Wade. First of all, from a purely legal standpoint, because that's not a legal argument, right? There's absolutely nothing legal about that. And Roe v. Wade, as we've pointed out to death in this opinion, just reading the opinion, the justices themselves beat this to death. Roe v. Wade was just plain dead wrong. There was no real legal reasoning behind it. There was no historical reason behind it. And the only argument from a white nationalist perspective to keep abortion is birth rates, is demographic war, right? We need to keep it legal so that these non-whites will destroy themselves and not raise the birth rates through the roof. That's the argument. So even leaving everything legal aside, the moral argument against that is it is moral. It is a moral argument. Like, yes, there's obviously demographic war, and I'm stating that from an historical perspective, not a political one. We have no political opinions on this program, okay? But obviously there are demographic wars all throughout history. But saying that we should legalize murder for this group we don't like is just the depth of depravity. It makes you contemplate this whole notion of race. We say that there's, and by we I mean the general we, I am not personally included in this, but we as human beings say that races have a destiny. Races have these certain characteristics. Races have X, Y, and Z. Is it not hypocritical to say this particular race that I will not name has this destiny to do A, B, and C, and yet this race shares no collective guilt whatsoever for the actual evils it has committed? Every race thinks that about every other race, but they don't want to think about themselves, and that's a very human thing, because we all want to see all those faults in everybody else individually, right? But we don't want to take personal responsibility ourselves. Like a husband, for instance, who would have an extramarital affair, destroy his own family, and then deny responsibility for it. Say, well, it was somebody else's fault that this happened. Even blame the wife, blame the child, blame everybody but himself. Ultimately, the responsibility was with that person, but we don't want to look at that. Likewise, yeah, you could say, well, the slave trade, it was all Jewish people. At the top, they were the ones doing all this. We white people had nothing to do with it. Our ancestors had nothing to do with it. Our ancestors, that is. And by the way, we weren't even alive. Has nothing to do with us. Yeah. You could also say, well, it was all these foreigners coming in here and, making usury legal, raising interest rates on credit cards, and it was them. It wasn't us. Yes, it was. Yes, it was. You don't get to point the finger at other people and say they committed usury. They allowed slaves to come in here. We had nothing to do with it. If you didn't worship money, you would not have allowed that. If you didn't worship commerce, you wouldn't have allowed these things to happen. And if there is such a collective thing as race, then races have responsibilities as well as destinies and rights. There's this whole book called The Philosophy of Fascism, which I would never endorse, certainly not on a legal program like this, that discusses this phenomenon of people clamoring for rights all the time. We have the right to do this, we have the right to do that, but they have no responsibilities whatsoever. And so those fascists, those evil, warmongering racists, who we all hate, they started saying, we need to talk more about duties and responsibilities, and we need to undertake these responsibilities ourselves, rather than talking about our rights to do this, our rights to do that. What are our duties? That's what's going to get us going. That's what gets us out of bed in the morning. What is my duty? What must I execute today? What are my obligations to my family, to my community, to my country? All of which is to say that saying we need to keep a clearly erroneous legal decision like Roe v. Wade because black people get more abortions than white people is just the height of immorality, in my opinion. And I realize that will not make me popular amongst a broad section of a certain political group. But number one, we have no political opinions here. Number two, those people are just wrong. And number three, this is a legal analysis. We have 7 minutes left. We didn't even get to talk about New York State Rifle Association, but I don't care. It's not that important a decision anyway, if you ask me, even though it did overturn, allegedly, a 100-year-old New York state law restricting concealed carry. The most important line in it is something like, there's no distinction between the public, in the Second Amendment, there's no distinction between public and private in the right to bear arms. But then they go on to say, well, you can, however, require licenses for this. So there is a distinction between public and private. But whatever. We can talk about that next week. So the Solicitor General suggests that history supports an abortion right because of the common law's failure to criminalize abortion before quickening, but the insistence on quickening was not universal. And regardless, the fact that many states in the late 18th and 19th century did not criminalize pre-quickening abortions does not mean that anyone thought the states lacked the authority to do so. Instead of seriously pressing the argument that the abortion right itself has deep roots, supporters of Roe and Casey contend that the abortion right is an integral part of a broader entrenched right. Roe termed this a right to privacy, and Casey described it as the freedom to make, quote, intimate and personal choices, end quote, that are, quote, central to personal dignity and autonomy, end quote. Ordered liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed potential life. But the people of the various states may evaluate those interests differently. The nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. We can't even get through the holding part of this, let alone can we get through the 213 pages of this opinion. But I hope that serves at least as an introduction as to what happened today. Roe v. Wade is dead. Praise God. It is over. And now, we all have to deal with the fallout. Or should I say, in the Tony Robbins sense, we all get to deal with the fallout. Hallelujah. Till next week, everybody.